4-0. Present in the virtual courtroom, we have both parties as well as their respective attorneys. We are here today on the defendant, Mr. Roderick's motion for a temporary order. I have read both the motion and the response, so the attorneys don't need to go through all of it in excruciating detail. But Mr. Quinn.
Yes, thank you, Your Honor. So reading the response, it looks like there's at least one agreement with temporary joint legal custody. I saw that in the response. We attached to our motion as Exhibit M the rights and responsibilities for a joint legal custodian that I think there is an agreement on. I don't know if I got that unequivocally.
That's correct, Your Honor.
Okay, good. Thank you.
And then the next that I didn't really see addressed in the response was our proposal, which is attached as Exhibit N to our motion about the inherent rights of the minor child. I can't imagine there would be an objection to that, but.
Ms. Slate?
Going through the 88 pages, Your Honor, just 1 second.
Sure.
A long one.
It is a long one.
All right. I don't know why we have to parse it out into separate orders. Couldn't we just include that as the temporary order today, Your Honor?
That's the ask. It's
Okay.
just the language that we included. I don't know.
I think he's just confirming that there's no objection to what is proposed on that.
Okay. Yeah. The Exhibit M and N, that language could be included. Yes.
Good. So 2 down, handful to go still. So as the court indicated, I'm not going to regurgitate what we've put in our response. I know it's long. As a practitioner, and I know the court has presided over these number of years, these motions for temporary order are hard because it's right at the inception of the case, and we need to give the court as much evidence in detail as we can to support our request and show that they're reasonable and appropriate. And I think we did that. Our first ask is with respect to the party's daughter. We're requesting temporary joint joint physical custody and parenting time as detailed in the motion, specifically every Wednesday overnight and alternate weekends, Friday until Sunday. As detailed in the motion, historically, Mr. Roderick has been actively involved with the party's daughter. We listed a number of activities that they share together, and they have a strong bond between them. Unfortunately, since the parties physically separated with Mr. Roderick moving out, he's been unable to get any real meaningful parenting time with their daughter, apart from a few hours a week, which the plaintiff allows. Now, our response to that is there's no reason to drastically limit his time with their daughter to that extent. That's extreme. He's been historically actively involved. He's had considerable time with her, unsupervised for extended periods. And as I know this court is familiar with the statute on parenting time, the parenting time has to be granted in a frequency, duration, and type to promote a strong relationship between the parent and the child. A few hours a week does not. Now, reviewing the response, I note that it doesn't appear to be verified at all and appears to include a number of general conclusory allegations that, well, he's abusive, well, he has an alcohol problem. They provide really no details with respect to that, no specific examples. The only evidence or document they attach to support these claims is a police report that I trust the court's reviewed that is, for lack of a better term, totally uneventful and from over a year ago. Now, they claim in the response that he can only go a couple hours without having a drink. Again, we think that's totally baseless. I want to point out, and we noted in our motion, that Mr. Roderick started a new job not too long ago. And in connection with that job, he underwent a alcohol and drug screen, which he passed. And they were looking at him particularly because he is at times going to be driving a company vehicle and can't have any issues with alcohol or drugs. passed that test. There's no concerns. He doesn't have a history of a DUI. He doesn't have any alcohol treatment or anything like that. Then there's these allegations of abuse. I want to point out there's been no criminal charges ever against him, no arrests, just because she's called the police maybe a few times to get a report doesn't necessarily translate to him being this terrible monster. And I would like to reference the text messages we attached to our motion. They show that many times the plaintiff is aggressor in their interactions. She claims, well, the text messages we provide are out of context and misleading to the court. Well, they didn't provide any other messages to clarify that. Where are they? Claims that he's so terrible, yet she's inviting him over to the house on a regular basis to help with things doing this, help with things doing that, to help with their daughter. I just think these allegations should ring hollow with this court. Now, if we're willing to agree to a provision in a temporary order that's mutual, that neither party will consume alcohol 12 hours prior during parenting time. We don't think this case warrants such a drastic and frankly expensive involvement of SoberLink, which I know this court is aware of. That's an extreme measure to use in extreme circumstances, which we don't have here. But if the court is inclined to order the same, obviously we will comply with that, but we would ask that it be 1, mutual, 2, she pay for it, 3, that it be only for a short duration, and also ask that the court would look at alternatives to that. I have recently been apprised of a competing program called Keeper that is significantly less in cost. It's spelled KEEPR. Now, I also want to point out that I thought the response sidestepped an issue that is quite important. The plaintiff's mental health, which is documented. We need some assurance that she's seeing her counselor regularly. She's on whatever medications need to be prescribed, or an open flow of information with that respect, because we have concerns about her history of mental health issues. Now, they're in the response, they reference, well, he's no-showed for parenting time. We disagree to that. They reference in the response that he's refused parenting time. Well, I think we can admit that on a couple of occasions, he had to decline some time because he was given notice at the last minute, already had plans that he couldn't move, which is part of the reason why we're requesting a specific schedule in the first place, so he can base his life around it and do what he needs to do to exercise all the time afforded to him. He's not asking for 50-50 parenting time. He's asking for 1 overnight a week and alternate weekends from Friday to Sunday. Now, the next request in the motion concerns nesting. There have been, or the plaintiff has brought up in the past, that she does not think that where Mr. Roderick is residing temporarily is an appropriate place for their daughters to spend even 1 overnight. We disagree with that. We've attached photos of where he's temporarily residing. It's in a campground where lots of families are. But to eliminate that concern, we propose a nesting, which would be best for their daughter. She stays put. She can sleep in her bed every night. It doesn't require the parties to have any additional interactions. It will ensure that the marital home's kept reasonably clean. And she has a place to go. She has immediate family within only a few miles of that house that we believe she can stay at no cost to her. And minimizes costs for both parties, because Mr. Roderick's going to need to secure a new residence. This is just a temporary arrangement. Last, with respect to finances and support. In support of our motion, we attached pay stubs. We attached an excerpt from the party's historical tax return only a few years ago, with her earning approximately $50,000. We attached both child and spouse support calculations with variations of income. I did note in the response that the FOC is apparently doing an investigation as to child support. I don't really know how that came about. He got some documentation just the other week, and so did my office, that he needed to submit a income questionnaire, which was due last Friday. He did, but I don't know how that came about. So just for the court's information, it is in the works for at least
Let me
the
just stop you a
support
minute,
group.
Ms. Slate. Do you know anything about that? I found that odd too.
I don't, Your Honor. I can have my staff call and see if there's another docket sheet, but I don't know why they would have received that. I don't have any paperwork on that.
Okay. All right. Thank
Yeah.
you.
We attach as Exhibit L what he received, and it's this case number.
Yeah, I found that odd too. So
Yeah, that was bizarre. Now, in the response, they report, well, she shouldn't be imputed income because she has this medical issue. We agree she hurt her foot and underwent a lot of stuff, but that was in the past. She has a history now of earning $50,000 a year. It wasn't a construction job where she's doing strenuous manual labor from sunrise to sunset. She's interviewing now. I believe she had an interview just the other week. She just traveled to Florida without any issue, from our understanding. She regularly drives. She claims she has work restrictions still, but none of those are listed in the response. We don't know what, if any, of those actually are, or if they are self-imposed or doctor ordered. Now, we think the court needs to impute some income to her. It needs to give her some incentive to work and not have Mr. Roderick shoulder all of her expenses, all of his expenses, and shell out support to her. Now, the response also proposes that the parties simply divide all income. We attach the pay stubs. That would account to her getting north of $4,600 a month. That is way higher than what our support calculations show to this court, and gives her a considerable windfall, puts Mr. Roderick in a financial bind where he can't secure new living arrangements or really do anything to get himself on his feet and get a more long-term arrangement in place. It's way more than her expenses. Now, as detailed in the motion, he's willing to continue to pay certain expenses on her behalf. We've detailed those in the approximate amounts in our motion, which equates to pretty much what his support obligation would be under the calculations. And rather than shell out money to her, where she needs to turn around and pay these various expenses, which his name is on, he just rather cut her out of the middleman and pay those expenses directly to ensure that they are being paid, especially those in his name. Now, I don't have any other things to add unless the court has any specific questions of me.
no, Ms. Slate.
Your Honor, I will try and be brief. This motion is 88 pages long. It includes a number of exhibits, and it is just a recitation of statements made by Mr. Roderick. This is classic gaslighting. Ms. Roderick was in a physically and mentally abusive relationship for a very long time. She now has left the abuser. So what happens now to regain the control that Mr. Roderick has to have? Well, we see exactly what gaslighting tells us. He's going to say she's got mental disease and try to convince those people around Ms. Roderick that that's true. You'll see in the text messages that Mr. Roderick attaches, Ms. Roderick says that he tells her to go kill herself because she doesn't make him a sandwich. We have a 9-year-old child, a girl, in this situation. Mr. Roderick isn't requesting extensive parenting time because he knows he cannot handle it and he cannot be appropriate. And that has been consistent throughout this relationship. Ms. Roderick has maintained the role of gatekeeper. And what we don't want to have is a 9-year-old girl subject to an abusive father. He cannot control his alcohol consumption. In fact, it's increased since the parties separated. 316, his phone location showed him at a bar in Chicago all day when he was supposed to be down there helping his mother. The entire day at a bar. And that just continues. The alcohol consumption whether or not it's led to an OWI. Clearly, he calls friends to pick him up when he's been drinking from the one police report we were able to get. This motion was filed late Friday afternoon and is 88 pages long. FOIA requests would take us at least 5 days. But they also don't have any evidence of her mental health or bipolar disorder or suicidal ideation. There's no suicidal ideation. He asked her to go kill herself. That's ridiculous. I'm glad Ms. Roderick is taking a step forward to get away from him. We need to protect Charlie. The parenting time that they're requesting should be supervised to start out with. We need to see if Mr. Roderick, for extended periods of time, can act as an appropriate parent. We don't believe that he can. We do not believe that he can refrain from drinking alcohol for that amount of time. He has a relationship with alcohol that supersedes both Ms. Roderick and Charlie. And we need to carefully monitor that. As for the income, the total expenses for Ms. Roderick at the home are $1,828.24. That's the mortgage, house insurance, car insurance, phone, and her student loan. That doesn't include utilities. So she's got to clear $1,828.24. Mr. Roderick is living in a friend's trailer and doesn't have any rent payments. So his only expenses are his food and clearly his alcohol, which we'll be getting those bank records and credit card statements. The total household income is $8,418 for the month. I think it makes sense to divide the income. Have Ms. Roderick pay her expenses, and then she can have additional funds for groceries and the like. What he's done, and is classic of abusers, is also engage in financial abuse. Since the separation in March, Ms. Roderick can't have access to money. What he does is, I'll go to the grocery store for you and I'm going to drop off what you're going to eat. Or I'm going to move back into the house. And all of these other abusive tendencies. If he was so concerned about the living conditions of Charlie, or if Ms. Roderick had these mental health concerns, why wasn't he back here in March? Why didn't he rush into the courtroom in March? It's because they're untrue. Absolutely untrue. So we would ask the court to provide him with a limited parenting time schedule to start, that schedule be supervised, that he not drink alcohol during his visits. We would ask that the household income be divided for now. And Ms. Roderick would then be responsible for paying the expenses of the place in which she's living. And we'd ask that it be sent to the friend of the court for review on that parenting or the child support, which it looks like it might already be, and I have my staff looking into. And other than that, we're agreeable, like I said, to the joint legal language and also the inherent rights, which is just standard language for a temporary order.
All right, thank you. Well, I will refer this matter to the friend of the court for a review regarding child support, parenting time, and custody. It sounds like the child support's already started, which is, in this case, is good. I will, as far as temporary custody, physical custody, I will grant the plaintiff temporary sole physical custody. I'll grant Mr. Roderick parenting time rather than overnight on Wednesdays on a temporary basis again until we get all of these allegations sorted from 5 p.m. until 8 p.m. Every Wednesday, alternating weekends as proposed by the defendant, which is alternating weekends, Friday after school, if no school, at 5 p.m. until Sunday evening at 5 p.m. That is all subject to participating in either SoberLink or Keeper. I've not heard of that, Mr. Quinn. If it's less expensive and reliable, I have no objection to using that. Ms. Slate, do you have any idea about this keeper program?
I have not. There's also the backtrack program, so I guess we could look at all three and determine which one meets the needs in terms of alerting Ms. Roderick.
Okay. Yes, I mean, we're not in the business of trying to enrich these companies that do this. So if you can find a less expensive, reliable option, I'm all for that. I don't want the parties spending money they don't need to spend. I will also grant the plaintiff exclusive use of the marital home. I do not think, given the allegations that are flying back and forth, that a nesting arrangement is appropriate. I think that just exposes this child to even the potential for more tension, which children definitely feel in these situations, even and actually blame themselves often. As far as payment of the bills, the defendant on a temporary basis shall pay all of the bills that he indicated in his motion, as well as a $500 amount to go towards groceries and utilities and other things. And I'm hoping that the plaintiff will be obtaining a job so that that will not be insufficient. And is there anything I've missed?
I have some clarification questions, Your Honor.
Sure.
So the referral to the front of the court for child support, parenting time, and custody, would legal custody be included in that?
The parties have agreed to legal custody, so no, I don't think that's necessary.
And then you said some alcohol monitoring device. One, is that going to be a mutual?
There's no
I haven't heard any allegations that Ms. Roderick abuses alcohol, so no, it's not mutual, but I will indicate that neither party should be using alcohol during parenting time. And I meant to say this and I didn't, that requirement is for 90 days. That should give us a good baseline.
And who will pay the cost of that?
Mr. Roderick will pay, and that's something that can be worked out. If there should be any shifting, that can be worked out in the final settlement or trial of this case.
He pays the bills identified in the motion plus an additional 500, and we can just classify that as family support.
Pending the child's, I'm hoping that the child support recommendation will come out sooner than later, since it sounds like they've already started it.
Yeah. So, but temporarily 500 family support, that directly to the plaintiff.
Yes. Ms. Slade is nodding her head. So that's, yeah.
Okay. I don't have any other questions.
No questions on my end, Your Honor.
All right. And is there anything further?
No, I'll prepare the order.
All right. Thank you. We're adjourned.
This is just easier than typing all of this. I looked through their docket, and it's actually incredibly short. There were no other hearings other than the pro-con to take the proofs and get their divorce. They had a very successful mediation and pretty much ended up with everything requested by Dad. Reasonable child support, reimbursement for some of those fees on the SoberLink. It doesn't give me the details, but anyway, he got some of that back, so clearly it wasn't as big of an issue. Mom's not worried about safety for that child. If she was, there's no way that mediation would have gone so quickly and that there would have been almost immediate settlements and mediated settlement agreements that didn't take long to arrive at. Less than 5 months from the hearing we just watched, their final judgment of divorce was entered.
3DM. Present in the virtual courtroom, we have both parties as well as their respective attorneys. We're here on the defendant's motion to enforce the judgment of divorce, as well as the plaintiff's motion regarding support, and I'm trying to get to the title here, support, child support, appointments, speech evaluations, alienation, and transportation. So there's a lot. I don't know which of you wants which of you wants to go first, and I have read all of this.
I don't
So
have
you
a
don't need-
preference.
I don't either. Ultimately, it's up to the court. Everybody's going to have to address everything, and I prefer.
All right, why don't we go with the motion, the defendant's motion to enforce judgment?
Okay, Your Honor, can I address everything, or do you want me to wait for opposing counsel to make her arguments? I can do either. That's fine.
As long as you break it down so that I can follow it.
Yeah.
Like I said,
yeah.
I have read everything, but there's a lot here, so.
Right. So really, Your Honor, I think the biggest issue here is there's a lot of requests. Much of this can't be done on a Friday morning, which is unfortunate. But ultimately, I think that it's important to note that a lot of these requests being made, at least by Ms. Gibson, are pretty extreme in light of the fact that this case has only been before the court one time on a post-judgment issue for transitional kindergarten, but that issue was resolved by agreement. Many of the complaints also listed by Ms. Gibson are related to issues that occurred in 2023 and early 2024. The court hadn't even really seen these parties during the divorce case. It's because they were able to work it out. I think it's notable that mom's motion was filed really after dad made a request, which we made in our motion, to receive reimbursement for his daycare expenses, that she really forced him to pay despite the court order. Ultimately, really after reading through everything that was submitted, I'm of the firm belief that these parties would be well suited, and it would be best for the minor children in this case to attend co-parenting classes with Marge Lucas. I have had a lot of success in my other cases. I attached detailed information regarding her co-parenting classes to my response. Nearly really every issue raised in these motions, besides the support and daycare issue, are related to issues addressed by Ms. Lucas in her classes. This is substantially cheaper than a request made by opposing counsel to utilize Ben Burgess, who I understand is $7,500 to $10,000. Ms. Lucas's classes are done at a fraction of the cost for both parties. It's an 8-week course. It would be $760 a person. And ultimately, that's what we're requesting, Your Honor, today, is that the court order the parties to attend those classes. With respect to the actual issues regarding this case that are related to co-parenting, we have, really an issue of physical discipline. The judgment provides for no physical discipline. My understanding is opposing counsel's indicating none was done. She's complaining about my client recording the minor children repeating statements they made to him. My client wasn't using that for any purpose other than to inform mom that this was what was being said. It wasn't used for court. It's not meant to do anything other than try to ensure that the children are being safe and feel comfortable at both homes. My client would like to know if the children are saying anything about him during mom's parenting time. The recording was done because Ms. Gibson doesn't believe anything my client says verbally, but ultimately I understand the court's position that stuff has not been happening and will not happen. If the children raise issues with him, he will work with plaintiff in order to ensure that he's providing her the relevant information so that she knows how to react and how to communicate with them moving forward. I would note that unfortunately in this case, this isn't just a matter of the kids having just any single bump and bruise. These were issues with bruising on the face, bruising on the hand, like the minor child running away, screaming and crying, saying she didn't want to get spanked. I mean, these are things that were happening. They aren't currently happening because my client made Ms. Gibson aware that CPS had advised him to document, which is what led to him bringing the children into urgent care and recording. But after discussion with me, that's not going to continue. If there are issues that are relevant and deemed worthy of a CPS investigation, that's obviously the route that would be taken. But again, the hope is it's not an issue, since opposing counsel is indicating that Ms. Gibson is not using physical discipline. With regard to information being provided and filling out forms, I think much of this case will be resolved by just each party filling out their own information for the relevant care providers. I indicated in my motion that there has been a lot of concern related to Ms. Gibson filling out forms, not providing the care providers that my client's a custodial parent. I provided proof of that. I know she wants to poo-poo it and say, she didn't do that. It wasn't her fault. He should have figured it out. He did his best, right? He had to work with the school for months to figure out why he wasn't getting emails. The emails were going to Ms. Gibson because he was signed up under her email under data access. When he signed up for the kids, he couldn't select data access because somebody under his name already had done so, and that was mom. This is something that was happening at the daycare. There has been an alignment issue here. Again, the hope is that this co-parenting class can assist the parties in moving forward and to ensure that this does not continue. With respect to the request regarding the OFW, my client's happy to use our family wizard. They've been using it. He would like the court's formal order to be entered so that the parties are responsible for inputting information on the calendar within a certain time frame, and responding within a certain time frame, and that will help the parties. We have a request, Your Honor, in our motion related to mom looping dad in on where she's going to be with the kids. Typically, mom's communication to dad is, hey, we're going to Wisconsin, really little notice, doesn't say where they're going. All my clients really asking for is pretty typical in these cases, is if they're going to fly, take a bus, or go on a train, that he be given that information, and then just know the city that they're living in, or not living, excuse me, but visiting, so that he can ensure that he knows where they are in case of an issue, you know. If the plane crashes and my client doesn't know whether they were on a plane, that's really concerning. Obviously, that's an extreme example, but it's just information that most parents would want to know, and they should be able to be entitled to that information. It's not to micromanage her. It's just knowing where your kids are. And unfortunately, mom refuses to provide that, while dad is absolutely happy to provide her that information. With regard to the request for a speech evaluation, this is not a suggestion by any third party in this case. My client was told by Ms. Gibson originally that this was some sort of referral from the children's primary care providers. That was not the case. And once he found out, he did decline to do the speech evaluation. The children are in daycare with my client, and the daycare facility has not noticed any issues with their communication. My client would really like to avoid having the children be evaluated if they don't need to be, for any purpose. I think it puts them in an awkward position. And ultimately, if a third party recommended it, that was a care provider for the children, such as daycare or their doctor, certainly he would not have an issue with supporting that. But at the end of the day, he doesn't believe it's a concern or necessary. Again, I think I know we talked a little bit off record about this. There's a request by mom to have the parties attend appointments every other appointment and just be responsible for scheduling every other appointment. The parties have actually worked really good together regarding appointments. My client hasn't canceled a single appointment mom's made. He has never, she's canceled one that he's made, but ultimately they have been working together fairly well over the last 2 years to ensure that both of them are able to attend these appointments. This is probably really relevant in this particular case because the kids are young and there are legal custody decisions that are typically made at these well child visits. So both parents should be privy and available to attend those. I also don't think that there's a need to really micromanage these parents in this way when that has not been an issue. My client also has this other co-parenting issue with respect to preschool. My client was asking that their children be enrolled in Greenville's Junior Jacket program, which is a program that they have as a preschool prior to transitional kindergarten or kindergarten. These children will turn 5, I believe, on September 5th.
They're 3.
Or excuse me, 4. I apologize. We'll turn 4 on September 5th. So ultimately, my client had requested that they attend this daycare. Their other child was able to attend a preschools type program at their last daycare. He believes that these children should be able to do the same, and believes that they're best served by going to a preschool program at Junior Jackets. I understand mom's position that she wants to ensure that the children are spending time with her as well. My client agrees. He loves spending time with his kids, but they just wants them to have an educational opportunity. My understanding is that there's a 2-day minimum if the parties have a joint account with Junior Jackets, which means basically that's how they fund Junior Jackets. If they do, 2 days is the minimum, and they could be permitted to have the education during that time. Again, it would also reduce the cost of daycare since the kids would not have to go to daycare on those days. There are a few other issues that were raised in these motions, Your Honor. One was regarding daycare. While it's really a matter of cost at this point, there was another issue with not getting equal information, which was similar to what happened during this last school year with their oldest. The prior daycare was employed by mom before dad got involved, and it was right when the divorce was filed. The parties utilized that provider, but unfortunately, mom had sort of laid this groundwork with the staff there, and it seemed that people were aligned. This resulted in dad not being able to get a key card for the daycare until the divorce was finalized. Dad wasn't even able to get crafts and gifts made that were sent home with other kids on parenting time days, but he wasn't allowed to have them. So he would see kids walk out with stuff. Their kids weren't getting it because it went home with mom only. It was really just quite egregious. He also received a private message from an individual who was employed there, noting that these were issues that were occurring. So then he submitted a subpoena, which obviously opposing counsel referenced in her response. It is also notable that she had access to teachers, but he only had access to the director. It did become a problem. Eventually, there was obviously a clear bias. Both parties, it was notified, or it was known that my client didn't agree to have the children's education being done there any further. So the parties had originally agreed to seek an alternate daycare. The parties had initially had communication back and forth. Mom wanted to tour some facilities that dad had looked at, but she never.
I'm sorry to interrupt, Ms. Van Tol, but
Yes.
I've read all of this,
I know.
so if you,
Okay.
if
Yeah. I get
shorten
it.
it up a
So,
little bit.
I mean, the issue ultimately, Your Honor, is now mom has basically forced this daycare arrangement where my client's been required to pay for his own daycare. This is a request that mom's been making since the divorce was entered. She doesn't like that she has to pay more daycare. She makes substantially more money than my client. She had been historically living for free with her parents. So throughout this last school year, my client has been paying daycare on his days when he works. And then in addition to that, my client, because mom set it up this way, has been responsible for before and after school care for their oldest on his days. Again, this is a forced request by mom. She's basically forcing him to pay despite the court order. She's asked for this agreement in the past. He has completely declined that. Again, there is a huge disparity of income here. And ultimately, he's asking that the court have the parties exchange daycare cost information and proof within 21 days so that we can do the calculation, hopefully without having to come back to court. The court order remains. There's no basis to deviate from that. There's no retroactive modification. This is no different than if someone had a medical expense, but ultimately mom wants to complain that she wasn't provided daycare information. I'll note the other daycare provider was harassed. They quit. Mom didn't provide her daycare provider information. So either way, it just has an issue that needs to be dealt with. With respect to the issue of support, mom's noting that she has $30,000 of decreased income. This is unknown to my client, and the timing's a little suspicious. But either way, if the court's inclined to send this issue to the front of the court for an investigation, that's fine. I noted in my response that my client is working as a parapro. He is engaged in largely full-time hours almost every week during the school year. He also picks up work as a coach and athletic director. I don't think it's appropriate to impute him since he's working to get education as a teacher through the Grow Your Own program through this school. With regard to the transportation, mom's requesting that her parents do transportation. Back in, I believe, 2023 or early 2024, there was an issue with mom's father being inappropriate in exchange. My client was very concerned about that, raised the concern, and indicated he did not feel comfortable moving forward with him going there. The incident resulted in the minor children not wanting to go with her dad, and it's just an unnecessary issue. It hasn't really been an issue. Now mom wants to utilize her parents. He's not comfortable with that. He's also concerned that she's saying that he can't record during the exchanges. The kids can't see him recording. The phone's in his pocket. It's just for the verbal. He's concerned about false allegations mom's raised about him in the past, and he does not want that to happen moving forward. And then I believe finally the one issue that another issue raised by opposing counsel is counseling. Again, no third parties indicating that this minor child needs counseling. She does well educationally. She does well socially. Again, dad's concern that mom's prior attempts to align individuals against him is going to continue with anybody else involved. But ultimately, the biggest issue is that no one else is suggesting that it's a concern. So we are asking that the court deny that request. Thank you.
Thank you. Ms. Tompkins.
Thank you. I'm going to try to hit the issues one by one and keep it as clear as possible. I know there are a lot of them. I'll start with that physical discipline. Miss Van Tol didn't know there was an order prohibiting that. I had to remind her there is an order. It's an order we requested. It's in the judgment of divorce. My client has not and does not and never has used physical discipline. The irony here is that she left this marriage fleeing the house in light of Mr. Gibson's physical attacks on her. So I have this whole narrative that he's trying to create. I'm not going to spend time on because it's false and diluted. I would ask that he's prevented and ordered to immediately stop recording the children. I find massive concerns with his inability to understand that what he's doing is putting false memories or false thoughts into these children's head by saying, oh, please repeat what you just said. Does mommy hurt you? How does mommy hurt you? There's a forensic interview protocol, and clearly he is not engaging in that at all. He's simply damaging the kids. This is one example of why this child needs therapy. Every single issue will continue to show why we think therapy is appropriate. As far as co-parenting classes, I have major concerns about the idea that they want to co-parent when what my client is adamant to do is parallel parent. There needs to not be, she wants peace and appropriate communications. She does not want him engaged in her life. That's why they got a divorce. Parallel parenting is an absolutely appropriate and the appropriate method to deal with these cases of high conflict. So I have concerns about the co-parenting class and of the cost, and in the idea that it's tries to make parents co-parent as opposed to parents parallel parent. As far as travel, my client provided information. She does tell him where she's going, what states, cities. She again thinks this is another function of his wanting to control everything, that he will demand and want the hotel, the phone number, every little bit of a full itinerary. I don't think that is necessary or appropriate. She is following the order that says that she will keep him notified of where she is in the event of an emergency. She has always told him if there's any kind of an emergency. So I would ask that that request of theirs be denied. As far as their daycare expense request, in child support, if someone fails to report income or hides information, they can retroactively modify an order. We have asked repeatedly for where the kids were going to school and cost information. We didn't find out until Ms. Van Tol attached a letter to her motion here. We had no information about the cost. They're saying it's the same, but that's not the true. The prior daycare had more days included. So I believe the cost is higher. They have provided zero information on it. And if she had known about this in the beginning, she would have been able to go to the court and ask that there be a modification of child support to include it. For child support, that issue, there has been a proper change. He's making more income. He just acknowledged, his counsel just acknowledged on the record that he's doing more work than he was, including summer work, including now coaching and doing additional things and doing full-time work. So my client's also making about $30,000 less than she was. So I think it's appropriate to send it to friend of the court and have whatever the party's child care expenses included. That's a function of the Michigan child support formula. It should be included directly into the formula. They can each pay their own expenses. They can report that to the friend of the court. and that can be included. That's how it is divided between the parties. As far as, again, going to his daycare expenses, she also has daycare expenses with the after school cost. And she has to have a nanny every other Friday for $200. So it should all go through the friend of the court and go to child support. For transportation, he again wants to control the situation. When my client asked what her problem was with the father, he had nothing to say about it. He refused to answer or try to resolve a problem. The exchange location is in a public place that has video recorders. So he also never provided, he was happy to provide video recorders of him talking to the kid, but he didn't provide her some recording that had her father doing something wrong. My client throughout that time period lived with grandma and grandpa, lived with her parents, and the children were very comfortable with them. She has work. She cannot always be there. It is absolutely appropriate to say that the parties can provide transportation through a person known to the child, that all parties will be civil or, quite frankly, not talk at all, and that there will be, it's in a public location, there's no threat of something happening, and that we can move along. That way there isn't continued entangled problems. As far as preschool, he puts on the white hat, but he enrolled them without her knowing, without her agreement. They can go 2 days, and if he wants to send them on his time and pay for it and have that be part of the child support formula, she's not opposed to it. These children are 3 years old. They don't qualify for preschool. So she would like to have the right on her parenting time to spend her time with her children. I think she has every right to do that. And for him to try to force her to pay for less time with her children, I think is abhorrent. My client has, again, no issue with them going on his time. If he would like to pay for them and enroll them, that's fine. As far as the speech evaluations, my client had spoken with the doctor about it. The doctor said if it hasn't cleared up or you don't see improvement, then you should seek out a speech evaluation. She hasn't seen improvement. We have a daycare provider that we don't know, from Mr. Gibson, saying, hey, I'm no professional, I have no training, but I think they're fine. My client has concerns. There's no hurt or harm in an evaluation. It's nothing strenuous. It's nothing problematic. It is far more problematic to put the children through going to urgent care visits for false bruises. So we don't see any reason that the speech evaluation shouldn't move forward, as it's a consistent concern for my client, and it does zero detriment to the children. As far as therapy, everything that we're here talking about today, I think, is a very strong basis for this child to engage in therapy. I don't see how that could be much more needed than that. As far as appointments, with the doctor's appointments, I'm not requesting, Your Honor, that anybody is prohibited from attending. They already know what vaccines they agree on. They've always had all of the traditional vaccines, and they've always said that the children will not have COVID vaccines. I'm not asking that anybody has a right to make any joint legal decisions by themselves, but it is a completely false assertion that there hasn't been constant problems with scheduling. My client has had to leave work because last minute Mr. Gibson has said, well, I can't get them there. And she's had to go and pick them up. She's had issues with rescheduling, escalation, and issues. And I don't see how it's a problem to go back and forth. If they are able to attend, they can attend. It's also a very typical thing with things like therapy that they would rotate scheduling so the other one can be there. Mr. Gibson will never agree to schedule when he has to work. And the problem has become my client constantly having to try to take off work or negotiate her schedule. So he says it's fine for him because he throws a fit until she takes off work and doesn't complicate his life. We're looking to have orders that will minimize the problems as to continue to exacerbate them. As far as the daycare expense, again, I would note his bad behavior. He has spent his whole motion minimizing everything he's done. But I personally was on the phone and said, if his behaviors continue, they're going to lose this really good daycare. Miss Van Tol and I had a conversation about that, and he persisted and persisted and persisted in harassing that daycare until they lost it. I just
Again,
don't
Ms.
think he
Tompkins,
should
I've
be
read all of
benefited.
this, so you don't need to go in depth.
Beyond that, I don't think I have anything other. Then I would like the court to consider adding that offer, deny their motion, grant my motion, and also include a prohibition from Mr. Gibson recording the children. Thank you.
Right. Thank you. I am going to order the co-parenting classes with Ms. Lucas. I realize that this is not cheap. It's $760 a person. But just listening and reading everything, something needs to change. This is horrible for these children. They're absorbing all of this conflict. Even if it's not in front of them, they're still absorbing it. They know what's going on, and they're going to blame themselves, frankly. That's what the research shows. I will also enter an order regarding our family wizard. I believe that I have a pretty comprehensive order regarding what's expected, and I think it will clear up a lot of these problems if both parties follow that order. And if they don't, then they may be held in contempt. As far as the outstanding child care bill, there's, I don't think, agreement regarding whether or not the bill was less than, more than, or the same as at the old child care facility. So I'm going to order today that mom is responsible for the amount that she would have paid at the old child care facility. If that's less, great. If it's more, great. I just don't know where else to go with this because it is clear that information has not been shared. Again, our family wizard, the order requires that all bills be uploaded. There's a time frame as to when they're going to be paid. All of that. I think that will clear this up going in the future.
Your Honor, to clarify that, he would be responsible for her costs that she pays for the after school and her Friday care as well, correct?
Yes.
Okay.
We have to can we exchange within 21 days so that we have that information and we can make that work?
I think that's appropriate.
Okay.
All right. And as far as, and I'm going to back up a little bit on the co-parenting classes, the next step will be, from the court's perspective, if things do not improve, there is a counselor named Ben Burgess who is extremely expensive. It's like $7,000 a person. And that will be what the court orders next. So I'm just admonishing both of you. You don't want to go down this road. You want to make these efforts. It's the best thing for your kids. You don't have to like each other. In fact, you can despise each other, but you do have to work together, just like in a business or an investment. These kids are your investments, and both of you are going to be involved for the rest of your lives with these children. So you need to put them first. Okay. Absolutely no recording of these children by either party. That is the absolute worst thing you can do. These children, especially at the age of 3, are highly suggestible. I just attended this week a judges conference where I spent an entire morning listening to presentations regarding forensic interviewing of children at this age, especially 3-4 years old. They are incredibly suggestible. And it also puts them in the middle. So do not do this anymore. I'll order that each party is responsible to fill out their own forms for whatever it might be, so that they are in control of emails, phone numbers, contact information, all that stuff. Our family wizard should be used to provide the contact information for the school, the counselor, the whomever. But then it's up to each party to do their own sign up so that they can have access to the information directly with the counselor, the doctor, the school. I'll order that each party is to provide general information whenever they take the children out of state, including the mode of transport and the city. Generally, you don't need to provide copies of tickets or anything like that, but just general information that is frankly just courtesy. As far as the speech evaluation goes, there's literally no harm that this court can think of for this child to have, or children to have, speech evaluation, and that should happen. That assessment is simply an assessment. If they don't need any further treatment, they don't have to have further treatment. But it's a rule out, and I think it's important to do, especially at this age, especially if there's any suggestion that there's an issue. Better to catch it early rather than later. I'm going to deny the request to alternate scheduling appointments. Again, I think our family wizard order will deal with a lot of those issues. As far as preschool goes, the request for junior jackets, at this point, I think that's fine, but during dad's time, I'm not going to impinge on mother's time. There's not much more time left before these children are in school, and so I am not going to order something that would intrude on either parent's parenting time. I'll refer the matter of child support to the front of the court. Childcare should be included. That's really what the formula calls for. Unfortunately, provisions such as in the party's judgment of divorce rarely works out, especially not in a high conflict case like this. It should be part of the child support. I will order that third-party exchanges are permitted as long as that person is known to the children and the exchanges are in a public location with a video that the location provides. And I'll indicate if it's the grandparents and anybody that's any kind of attention, they just don't speak to each other. Again, that is the best for these children. They don't need to be witnessing adults misbehaving essentially with each other. And as far as counseling for the minor child that was requested, I don't think this court has ever denied a request for counseling for a child, particularly in a high conflict case like this. Like I said, it doesn't matter whose fault it is. They take ownership. Even at this age, they will take ownership for the tension. They think it's something they've done. So I will grant that counseling. I'll indicate that the parties need to pick a counselor, and if they can't agree, the court will pick one. And I think that's it. Is there anything further?
As far as the speech evaluation, the only times he was willing to agree to were times that she had to take off of work. I'm just concerned about scheduling for that. That was.
Mom can schedule it. I don't think both parties need to be there.
Okay.
Your Honor, can my client be permitted to speak with the speech evaluator regarding his assessments of things before the speech evaluation takes place?
I would leave that to the speech evaluator. I know my grandson just had one not too long ago, and I know they spoke to both parties or both parents. They spoke to teachers. They gather information from all over. I wouldn't say before. I would leave that up to the person doing the assessment. Okay.
And with respect to counseling, try to probably pick one that's in network available. And I'll talk to Katie about scheduling.
I was going to say it's in everybody's best.
One is agreed upon, and if not, the court will assign.
We'll come back if we need you. Can we just ask for a status conference or something so we don't have emotions? That would be really helpful.
Yes, no, that would be great. I have no problem doing that. But it should be somebody, that's hopefully covered by insurance or, least expensive, whatever. So. Okay. And obviously somebody who also has credentials as a child counselor.
Yeah,
that's
child
important.
Play therapy.
Right.
Wonderful. Thank you very much for helping us. This was a lot.
All right. Thank you.
Present in the virtual courtroom. We have both parties as well as attorney John Shirley on behalf of the plaintiff, Timothy Young on behalf of the defendant, and Krista Benson, who my understanding is that plaintiff requested be present in case the court had any questions. I have read the motion and the response. Mr. Shirley, anything else you'd like to say at this time?
Your Honor, I don't know to what extent you know the history of the parties. I'd be happy to give you a brief summary if that would be helpful.
I think I have a pretty good handle on it. As I said, I read motion and response.
Great, thank you.
So you have nothing else you would like to add?
No, just that, my client is just concerned that this child really doesn't, know the defendant, and he had some unsupervised parenting time last summer and it did not fare well. And she's just happy to facilitate parenting time, but she thinks it should be supervised.
All right. Mr. Young.
Your Honor, I would take exception to that, frankly, and indicate that the parenting time did go well, unsupervised. No complaint was filed that I know of with the friend of the court or the court seeking to restrict any future parenting time, making it supervised. I would note just in the court's order from August the 23rd of last year, the court did acknowledge with her history in the case that it was clear that the plaintiff had obstructed the relationship or the continuing growth in the relationship between the child and his father. It's our simple request that he be given the 4 weeks in July, which is what the order contemplated. And I don't think there's any reason not to allow that to be ordered at this time. And that's what we're requesting. Thank you.
All right, thank you. Well, I don't see any reason at this point for supervised parenting time, so I'll deny that request. So the only issue then is the schedule. Mr. Shirley, I saw there was some question about the schedule. Has that been resolved?
No, the plan last summer was to wait until she received information relating to her fellowships and when she would be around and when she wouldn't. So the dates starting in late July and running through late August are the dates that will fit with her schedule. And I would request that the parenting time be fit in so that that schedule can be accommodated.
Mr. Young, you're muted.
I would simply refer the court to the order from the 23rd in which the judge said, as the defendant has a job as a university professor, the time that he is available is the 4 weeks in July, as he is starting a new term, the early weeks of August. So I'm kind of not surprised that the schedule I'm getting is for August parenting time, knowing that my client cannot exercise that. We believe that the judge's contemplation of the 4 weeks in July as being the time that he would be granted that parenting time. The only question is really whether it's uninterrupted or whether it's, broken up. It's clear that apparently she is going to be in Kansas City for a period from July 8th to July 23rd. I think it would work out perfectly if my client were to pick up the child on July 1st and he can exercise the parenting time in Grand Rapids. And when she returns on the 23rd, the child would be able to be returned to her at that time. And that seems to be a perfect solution for the schedule, at least.
Mr. Shirley?
Your Honor, I know that my client believes that that would be an absolute detriment to the child's mental well-being. She maintains that this child really doesn't know him. He has 2 15-minute visits by Zoom a week, and after the unsupervised visits last summer, the child was having nightmares. I asked the court to, I submitted a request for an in-camera interview with the child. I think that would be helpful. And I know that she's going to think that him having the child for 3 weeks unsupervised overnights is going to be extremely unhealthy for the child.
Mr. Young?
Yes, I just, again, Your Honor, I have to go back to again, the prior hearings that we've had, and I have not gotten the transcripts. I guess I probably could get those and make them available, but
the court is going to go by the order.
Yes. So the concern that we have had, this child knows his father. The only concern about what happened last summer was mom's attempts to disparage the plaintiff in front of the child. And so when the child came to be with dad, he would repeat things that his mother said about him that were negative. that he was to be afraid of him, that he's dangerous, all these sorts of things that I think are coming from mom, which in my mind creates a really important opportunity this summer that he needs to be able to, I don't say counteract, but to at least develop a relationship so that those comments that mom is going to make, and I have no delusion that she's going to continue to make these comments on into the future and in coming years, he needs to be able to have an opportunity to get to know his son. Now, granted, last year he did not have overnights, but he had 4-5 hours of time. It was without incident. Now, we are simply proposing that the natural progression, he's a year older. They do talk every week, 2 times a week. That has been interrupted from time to time. That has not always gone well because mom has not always allowed that. But this is a child that needs to have a relationship with his father. The father is going to spend thousands of dollars to come to the States and stay here for the 4 weeks. And so I believe that we don't need to make this any harder for this child than we need to have it made. I have, for one, nightmares have never been mentioned in any conversation between the plaintiff and defendant. I have requested in interrogatories the information about what these nightmares are about. I don't believe they exist. I believe that the child may have a dream from time to time and maybe comes into his mother's bed, but it has no connection with the time that he spent with his father last summer. I believe that the mother's proposal that the father come thousands of miles from India to spend 29 total hours with his son over 4 weeks is simply indicative of the animus that she continues to have toward him. And we need to really try to put a stop to that. And the way to do that is to give Mr. Kamat his 4 weeks in the summer with his son.
Your Honor, I just said, Mr. Shirley, I have a question for you. Is this child in counseling currently?
No.
Okay. And this child is how old?
5.
Okay. Given all of the allegations in this case, I think it's appropriate for this child to be in some counseling. I think it would be appropriate during the parenting time this summer that father and child go to counseling together. So I will grant father parenting time from July 1st to the 23rd. I expect this child to be enrolled in counseling, begin counseling individually before that. It may be play therapy, and I leave that up to the counselor that's chosen. And then whatever that counselor recommends in terms of therapy with father, that occurred during parenting time. But yes, this case needs to move forward. The relationship between the child and the father needs to grow, and everyone needs to support that and do what they can to support this child. Is there anything further? Yes.
Okay, so we're concerned, we're concerned about the fact that the defendant is not a U.S. citizen. He's here on a passport. We would, at the very least, request that he surrender his passport while he has the child. My client has concerns that he may have ideas of leaving the country with the child, and we want to make sure that that doesn't happen.
Mr. Young, are you willing to accept his passport and hold it while he's here to alleviate that concern?
Yeah, I guess I haven't talked to my client about that. He's not going anywhere. He's coming here for the 4 weeks and he's leaving. So to the extent that he doesn't need his passport and has other identification he can use, my concern would be if he's renting a car to get around town, that he may need some identification that is accepted. So I guess within the parameters of his being able to do what he needs to do while here, I don't have any problem with the passport being provided. I haven't consulted with him about that, but I suppose I could ask him that question now.
I have traveled internationally recently. I am just going to order that he turn that passport over before he begin his parenting time. So by that point, he needs to make arrangements so that he's rented a car. He's done all of the things that require identification, and then he will get it back in time to leave.
Okay.
Also, Your Honor, we don't have any idea where he intends to stay, what he intends to do, where he intends to go.
Okay, those details, he doesn't need to provide an hour by hour schedule, but he does need to provide the information to the mother regarding where he's staying, so where the child's going to be, but again, not an hour, even a day by day schedule, but if he's going to leave town with the child, where he's going, that just your basic information that any parent would need to know, but nothing in detail.
Very good.
Mr. Kamath, you do have an attorney, and so I won't allow you to speak at this time. All right, is there anything further?
Is that pickup would be at noon on the 1st? What would be the time of pickup?
Does noon work? Mr. Shirley?
Mrs. Swamp.
I would ask that the attorneys work out these details.
Okay.
If you need a case conference with me, feel free to ask for one if you can't come to an agreement, but the broad parameters are there. And of course, some of it's going to depend on arrival, departure, those kinds of itinerary items that I know have not been finalized yet.
Thank you, Your Honor.
Okay, we're adjourned. Thank you.
Thank you.
Present in the virtual courtroom, we have both parties as well as their respective attorneys. We are here on the defendant's motion order to show cause against the plaintiff for allegedly failing to abide by this court's order entered on February 28th of 2025. I have read both the motion and the response. Mr. Young, anything in addition that you'd like to say in support of your motion?
Nothing to add in terms of what factually is in dispute. I believe that I would indicate that in March, late March, there was problems with the phone calls and moms interrupting those. Since the filing of that motion or our motion, those seem to have resolved themselves, which is good. The problem that we frankly face is that there continues to be an attitude that dad really does not deserve any involvement with his son. And he still is trying to establish that. That starts with getting information about his school, childcare, pediatrician, and the counseling. My client did indicate that he received a notification from mom this last week indicating that she had changed the counselor again. That is of concern to us because when this started, the first counselor involved with the child was Pinecrest, excuse me. And that counselor, I believe it's Erica Van Sloten, had a relationship with dad, was working with dad. She had concluded that it was a good relationship. And she was in a position, I think, to help this child kind of navigate the conflicts that historically have been an issue with mom and dad. But shortly after dad's summer parenting time last year, mom discharged that therapist, and we did not hear about a replacement therapist until we got back involved in trying to find out what was going on. That new therapy, the new counseling organization, Arbor Circle, has been involved, but we have not been able to get information from them about treatment plans and goals or dad's involvement. I think in my motion, I include the information that there's an email that was sent to Arbor Circle basically saying dad has no legal or physical custody and disparaging his involvement in anything.
Again, I know all of this. I did read your motion.
So what's happened, however, is that mom has again discharged Arbor Circle, and her OFW message to dad has essentially said that he has outgrown that counselor or therapist or organization. I tend to think that in looking at Arbor Circle's web information, they make it clear that they have counseling services available for all ages, dealing with all of these family issues. So I'm just suspicious of, once again, counselors being changed with the child, not giving dad an opportunity to be involved in that process or get information. This is a continuing problem that we need to get resolved.
Thank you. Ms. Nusna?
Just a couple of brief responses addressing first the email chain with Arbor Circle. I think it's really important to note the context in which mom said dad does not have any legal or physical custody, which is dad has a habit, this is not the first time, of sending an old order from Ingham County that erroneously said he has joint legal custody. He provides lists to medical providers and tells them something that's not accurate, that mom has sole legal and physical custody. So she does correct it when he sends an incorrect order, copies his attorney on these emails, and no one says anything about the fact that that's not accurate. That's probably my secondary concern. My larger concern here is that this isn't about getting the information. And the reason I know it's not about getting the information about the child's treatment providers is because I sent Mr. Young an email saying, what information do you need? I'll put it all in a letter to you. And I believe he actually attached this email thread as well. So I'm not revealing privileged settlement discussions that haven't already had that seal broken. And the response was, no, she needs to look on our Family Wizard and find out the information she hasn't provided. If Dr. Kamath had any interest in actually receiving the information, the response would have been, yes, please put it in something on letterhead, signed by your attorney saying this is the treatment that's going on. But that's not what he's after. And I don't know whether it's Mr. Young or Dr. Kamath who's driving this, but someone wants retribution and I don't know why. Beyond that, discussing the minor child's counselor at Arbor Circle briefly, he was treating with a pediatric specialist and aged out of treating with that particular therapist. At that point, my client began knowing that he would have to change providers, began looking for another therapist, contacting people at HRA, Lead Light Counseling, Humankind Counseling, trying to find someone who would be appropriate, accepting new patients, had appointment openings that worked with the schedule. It's very difficult to find counseling appointments for children that aren't during school hours. And rather than immediately going to whoever could fit him in a school day appointment, she's trying to find someone who can both accommodate his academics and has experience in dealing with these patients. She did get a call back from, I am going to butcher this last name, Siradesky and Associates, that they have some openings and they're working on getting that scheduled. And obviously, as soon as a provider is assigned, that information will be updated. Beyond that, I think a lot of the issues come from the fact that the information she's providing, she's putting it in the Our Family Wizard information bank, consistent with the order that was entered, rather than sending it in these messages. So there's not an easy thread where she's answering each question, but when it says, where does the child go to school? She uploads the name of the school. I don't think she said Grand Rapids Public Schools. I think she gave the name of the elementary school and the name of the teacher. Likewise for the counselor with the pediatrician and all the physical medical treatment, that's all on the portal, which dad has already signed up for. When she enrolled the child in school, she provided the school with dad's email and contact information. I believe he was sent portal invitations at that point and did not accept them. Since then, she can't sign him up for the school's portal. All she can do is make sure they have the information. The burden is really on the parent who wants to receive the information to sign up and finish the process, download Power Schools or whatever app is used. She can't do any of that for him. So that's really where we're at, that the information has been provided. As far as the disruptions in the phone calls, I spoke with my client about it extensively. The one time she can remember is she did go back into the room to grab a water bottle she had left. She lives in a fairly small house. There's just not a lot of places to go. The parties have a couple of times now successfully changed times to accommodate travel schedules, and the calls seem to be smoothing out.
All right, thank you.
Can I add just one thing, Your Honor? It's specific the entry provide. I can't sign. The only one. The orders make it clear in all of those informations, and that's a problem. She's not been cooperating.
All right, thank you. I think I'm not going to find the plaintiff in contempt of court at this time. However, I will admonish her that she's awfully close because complying with the orders sort of superficially is not sufficient. More specific information, right down to the names, the addresses, the phone numbers, the emails. I do think it should be in Our Family Wizard. It shouldn't be provided any other way because that's what the court has ordered. But very specific information, and whenever there's changes, very specific information. I will also order that the plaintiff sign any releases that are necessary for the defendant to access information. And she's going to have to do that proactively. It is his burden to contact that provider, but then it's her burden to sign those releases and to do it immediately. I think the phone call issue has been addressed, it sounds like, so hopefully we will not see any future issues with that. I'm also going to order that there not be any further changes in the therapist without prior approval of the court. So
does that mean that Arbor Circle is where he should stay as the provider of care?
I am willing to allow this new person because it sounds like the whole, I don't want this child to have to miss school, but if that's required in order for him to get counseling, or in order for counseling to occur, then that's what has to happen. But I certainly appreciate the attempt to not take this child out of school for counseling. So that's what I'm saying. That it is best, I think. But if the only option is counseling during school, then that's what's going to have to happen.
And can we also include in that order that that person be identified before summer parent time? Parties have agreed would take place between July 5 and
That's all right. That person needs to be identified within 14 days.
Okay, thank you. Your Honor, there was one thing in terms of the summer parenting time we were trying to work out. Maybe you could provide us with some guidance. I think last year, summer parenting time, the court ordered that he turn over his passport to the attorney that was representing mom at the time. My client is in need of his passport during the period of time that he's exercising, because there may be an opportunity to visit family members that are out of state, and he just wanted to be able to have his passport and not have that be something that would keep him from visiting the country.
Obviously, that's an extraordinary concern for me, given that Dr. Kamath has no ties to this country other than the minor child.
Why does he need his passport to go to another state?
Well, he's concerned about, number one, ICE. If there is
So you have an attorney, your attorney can speak for you.
If he is designated, picked up, contacted by ICE, he has no passport, that is a problem. In terms of flying to, he's got family and cousins and uncles in New Jersey that he wanted to be able to visit with Matzia, and that I think is not unreasonable. Clearly, he can't do that without his passport. So I think that, we're trying to normalize as much as we can this child's contact with dad and his family. He does have family in the country, and he would like his son to be able to meet them.
All right, I will allow him to have his passport back. The child will not be allowed to travel out of the country without their passport. So I think that's sufficient. And given the current climate with ICE, I understand. And I do
understand, but I'm very concerned if we can have dad post a bond or do something. He has a business, a career, family ties to India. He's got nothing holding him here. This is a very contentious case.
Okay, what bond would you suggest?
There's no amount.
He has no money.
There's no amount of money that can match a child. So,
well, obviously,
I'm trying to come up with some sort of a solution that would give some teeth to keep Matzia here.
Okay. I can't come up with, I don't have anything else.
Yeah.
But as I said, it's also not in the best interest of this child to have his father removed or, arrested by ICE. That would be horribly traumatic. So those are my thoughts.
Yeah.
Thank you, Your Honor. And I appreciate that. It would, I think, help smooth things out this summer when he does come and visit dad.
All right.
Thank you.
DM present in the virtual courtroom. We have both parties as well as their respective attorneys. We're here on the defendant's motion in order to show cause against the plaintiff. I will indicate I have read both the motion as well as the response, and I'm very familiar with this case, having seen these parties pretty frequently recently. And Mr. Young, is there anything else you'd like to say about your motion?
No, Your Honor, other than this is, again, the fourth or fifth time we've had to deal with the same issue, and I'm at a loss as to, how to move forward. And principally, I'm concerned about the minor child and what's going on with the child. And I'm disturbed that based on the answer to the complaint, it indicates that the therapist is no longer going to be providing services to the minor child, apparently based on, what is going on between the two parties. Dad's just trying to get information, and it's been very difficult to get cooperation from mom to allow that information to be provided to the dad. So I'm concerned that this child is now not in therapy. I'm concerned that the calls are just not productive. There's the video's turned off. The child is unresponsive. There's clearly, in my mind, a transference of mom's anger and attitude toward dad to the child. That concerns me. So I'm not sure that you can solve that problem as much as maybe getting this child into a therapist, that there is going to be communication and a cooperative plan put in place for this child being helped.
Okay, thank you. Ms. Newsma?
I want to briefly touch on the therapist, just that the email was sent on the 10th. And I think the timeline is pretty clear that dad reaches out to the therapist, probably copies Mr. Young on the email. The therapist sees what's going on and says, I want nothing to do with that. Mom has reached out to the 3 therapists that were suggested. Obviously, she hasn't scheduled anything. By the time she found out on the 10th, messaged me. By the time I responded, this motion was already filed, so we knew we were going to be here. And at this point, I would hope we could get some guidance from the court on someone who might have the experience in this type of case to not immediately run away. Beyond that, I'm equally at a loss because I told my client to maliciously comply. And by that, I meant provide every single bit of information about the minor child and his treating providers on our Family Wizard. And that's exactly what she did. I wanted to know what Matt's shoe size was. And that level of information was provided. We provided releases for the therapist. The one thing I haven't been able to do is draft a blanket release to have my client execute because I don't have the ability to do that. We're here, we're willing to sign these releases and are happy to do it, but we need to know what releases are needed. Beyond that, with the phone calls, the child is 6. And I think at least some of the people in this room have watched a 6-year-old operate a touchscreen in the last couple of years, and a lot of things happen. So if you look at the call logs, you see that the camera's on, the camera's off again. What they've been doing this summer is doing the calls. He sits in the air-conditioned car. Mom stands outside because they're timed, so they happen immediately after he's picked up from camp. She's literally outside of the vehicle. She can't control that. We see some connection issues on both ends. Sometimes dad's video cuts out. Sometimes it's on her end. And you can tell in the log whether it's turned off or it's a connection issue. And nothing I'm seeing shows that anyone's doing this deliberately. Matsuo will turn off the camera for 3 seconds and then it's back on. So I'm kind of we can't, without being present, you can't force a 6-year-old to do anything. Even being present, you really can't. But I'm not sure how to better facilitate these calls beyond that.
If I might respond, Your Honor, we dispute that characterization. Obviously, the court did not allow either party to record these sessions. So all you can rely upon is one party statement that the mom is present. You can hear her in the background. Again, I don't know how we handle that, but clearly, I think one telling email that's attached to the response from June 6th. This is an email from the plaintiff to the therapist in which she relates to the history of counseling with Pine Rest. She indicates that the experience with Pine Rest was negative for Matsuo because he was afraid of his father, did not want his father in the counseling sessions, and they were not helpful. That is a lie. I mean, we can get the records from Pine Rest. Those counseling sessions were productive. The child enjoyed the interaction. What we have, though, back last year was mother refusing to accept your order that you had for summer parenting time, filing a appeal to the Court of Appeals or requesting an appeal, emergency hearing because of irreparable harm. That was denied. So we're dealing with a plaintiff that just cannot accept the fact that dad is going to play a part in her son's life. That's concerning. I'm granted, she doesn't want the information. I think if you look at those emails, it's very clear that mom is not wanting to cooperate with what this court's order said. And so that is concerning to me when you have mother then transferring to this child this inordinate fear, anger, and unwillingness to have an appropriate, normal relationship with his father. And I would say,
Mr. Young, I'm going to cut you off because Ms. Neosma was actually in the middle of her her response, I think.
I was, but I had pretty much wrapped things up because I think we do need to figure out a different system for the calls. Maybe we do need to allow the parents to record these calls for the next 6 to 8 weeks and see what is actually happening. Because at this point, we have 2 parents saying 2 wildly different things. Beyond that, I'm a little curious about where Mr. Young obtained his psychology degree to diagnose the minor child with transference, which is certainly a term of art in the medical field. But this is where we are, that we have a child who does need to get back into therapy. So that's my first order of business, is finding someone. I'm hoping we can do that today and moving on from there. But the larger issue in the past has been providing access to the medical information, and that's been done. So I'm really not sure why we're here on a show cause, because I can't see where my client has definitively violated an order. The allegations were that as of, let me look at my date just so I get it right, as of June 6th, as of June 4th, she hadn't done something that she was ordered to do before June 15th. And so I really don't know why we had a motion filed the day the order entered, that when she'd already complied. Specifically talking about the therapy release, she provided it on June 6th. The deadline was June 15th. Dad's already on the Corewell portal. Dentist and optometrist, I think, are the 2 that are remaining, and the information's been provided. I don't know that they're going to require anything from dad beyond these orders. And certainly, if I get a release, I'll tell her to sign it. And that's what we've done in the past. But I can't draft one. I don't have the knowledge to put the language in that the medical providers want to see.
All right. I will address the counseling first. I've been adamant throughout this case that this child needs ongoing, consistent counseling. The fact that the parents are in such conflict all the time is definitely felt by this child and internalized by this child. This child probably thinks that this is all his fault or her fault, because this is how children this age respond to this kind of conflict between parents. So it's very frustrating to the court that this therapy has been so difficult to get in place and keep in place. And again, it's not surprising that therapists are hesitant to take this case because of the conflict between the parents. So once again, I will indicate that a new therapist needs to be obtained and scheduled at least within 14 days. That there be no disparagement by either parent of the other parent. This is the child's therapist. So I don't want to hear that there's been any indication of how it's gone in the past. This is a new page. And if the therapist wants to know how it has gone in the past, the answer should be the court has said no. All right.
Do you want to cover the parties being present, that they should be present in the sessions only if the therapist wants them there?
Yes, absolutely. Okay. Again, this is the child's therapist. The therapist is in charge. If the therapist wants a party or both parties at some point, fine. But certainly initially, parents should not be present.
Might I suggest, Your Honor, that the child was at Pine Rest. I think there was a good therapeutic relationship at Pine Rest. Mom fired that counselor, and it's my understanding that this current therapist has recommended some evaluation. So if we could go back to Pine Rest, they could do an evaluation. They could determine just what's up.
What kind of evaluation was recommended?
She includes it in her last email. It's attached as exhibit to Mom's motion, exhibit 4.
ADHD.
Yeah.
ADHD. Okay.
Which Mom has as well, so we're not shocked.
No, and Pine Rest, I know, does that. So
the one concern that my client's larger concern with Pine Rest is it is a Christian-based organization, and she is not. And so she's not entirely comfortable with that and would prefer something non-secular.
Well, she chose it in the first place.
I understand that, but there aren't that many reputable.
What about Fountain Hill, Ben Burgess? Not Ben necessarily, but someone at Fountain Hill.
I don't know. Do they do ADHD evaluations? I haven't heard that.
Google.
Well, Fountain Hills, in my experience, will cost tens of.
It's expensive.
It's a very, very expensive. My client is, in between jobs, and look, this has cost him a lot of money, and it has been very stressful on him. So much so that I don't know how much more he is going to be able to try to move the ball up the hill. And so obviously we've got a logistics issue. And
all right, well, let me get the answer here, Mr. Young.
All right, so it looks like Fountain Hill does, but Dr. Swantrakesh also just suggested there's a location called Headlight Mental Health Care that's, let me see, lasting affordable care tailored to work for you. They do a lot of ADHD work and the evaluations. It looks like it's a larger chain. Probably, as we know, the national companies are buying up the local businesses left and right, and they take their insurance.
Okay. Do you have any connection to that? Does your client have any connection to that company?
Ramya?
Yes, Your Honor, if I may. I did call them, and they said that they could schedule the evaluation as well as the.
Okay, but nobody you're related to works there or owns it?
No, God, no.
Okay, that's kind of what I was asking. Okay, all right. Sounds good to me.
Can we make certain that there is a remote access, that my client can participate remotely with whoever the therapist is? I mean, that was
if they yes, and again, I'm leaving that up to the therapist for both parents.
Well, and at this point, I can't imagine that anyone doesn't have that as an option, given what we've been through in the last 5 years.
Let's just confirm that. I can't imagine either, but let's confirm it before signing.
Did you discuss virtual with them at all?
Yes, Your Honor, they did say that they do virtual when needed.
Okay.
And so, Your Honor, if I could just clarify that the therapist would be provided through this, what is the name of the therapy center?
Headlight? Yeah. It sounded like the evaluation, and then for the therapist, maybe looking at the ones that were recommended by his other therapist. Am I correct about that?
So Headlights would do the evaluation, and then the parties would pick up, or there would be the last therapist made recommendations as to who else might be appropriate.
So we will go with the recommendation of the Headlight evaluator, so that we're not cherry picking who is going to be a therapist to maybe believe my narrative, whether it's mom or dad. because that's the concern.
I understand, Ms. Newsma.
I've been saying headlight because I was reading a chat from my client which had a typo. It is lead light counseling, which makes a lot more sense.
Lead light. Okay. All right.
Because lead light is based in West Michigan, where
okay. All right. Lead light. All right.
And so I'm clear, Your Honor, you are directing that neither party is going to be talking to these evaluators, therapists, giving their disparaging, experience with the other party. This is a neutral evaluation, a neutral therapy that's going to be provided.
And only providing the basic information, not any opinions about each other.
Very good, Your Honor. And in terms of the ability of my client to then access the therapist and information, my client's frustration was we had a hearing on May 15, which you made very clear what you
I understand all that, and I will get to that. Those releases, again, I also understand that they don't all use the same release. Exactly. So, and it sounds to me like the plaintiff did respond and signed the release within a day or two of being provided with it. And so I can't find her in contempt.
Well, it took 4 emails.
I understand all of that, but that's still a reasonable time to respond. But it's going to be his responsibility to obtain, once she's provided the information regarding the doctor, the school, whatever it might be, counselor, then it's going to be his responsibility to obtain, we lost him, obtain the appropriate release for her to sign. It's not going to be on her, it's going to be on him.
Well, okay. That was my situation when I communicated with Laura. As I told her, he doesn't know who those specific providers are. He doesn't know what their requirement is.
Well, again, so, that's what I'm required. She's required to give him the information. It's going to be on him to contact them and get that release and get it to her.
And the information is all in our Family Wizard already.
Yeah.
But the problem was he contacted every individual that she had said was a provider. Those individuals that he contacted, none of them would talk to him. None of them would even send him anything. So what we need, and what I'd ask Laura, is to say, you know who the providers are, just get their release, put his name on it as the father, authorized to receive the information. And I think that is going to streamline this process far more than, I just don't want to have to come back, Your Honor, to get releases when he's not able to. I mean, this therapist, for example, he sent a number of emails to her, and she basically said, no, I can't talk to you. I'm not going to tell you anything. I need releases. Well, Your Honor had ordered her on the 15th of May to give a release, and he's getting an email from the therapist on June 4th saying, I don't have a release and I'm not going to talk to you. So he's frustrated, and I just want to.
I understand. All right, I understand.
But I'm not a secretary.
That's the thing. I mean, I think that providing those providers with a copy of that order and just saying, I need a release. You don't have to talk to me, but you have to give me a release. Give me your form release, your blank release, and he can fill in the information and get it back to them.
Well, she's got to sign it, though.
Yes. Yeah. True.
But
again, that's what our Family Wizard is for. I mean, it just shouldn't be this difficult.
Well, and I believe she's set up to do I know for me, without me using my electronic signature platform, she's got set up for electronic signature. So if he uploads it to the Wizard, she can send it back signed.
Yeah, and I can't remember what that order says, but there's a time frame for responding.
Yeah, the Our Family Wizard order is pretty thorough.
Yeah. So whatever that is.
So if she provides specific information through OFW of the address and name of each provider with contact information, you're requesting he then contact the provider and find out what is required by way of a release. If they don't respond to him, can I have alternatively that she? Yes.
Then he needs to let her know with, the proof that she needs to obtain the release because they're just not communicating with him. And then I'll shift the burden at that point.
I just want a solution, and I want this child to be able to, have a functional, productive relationship with dad, and it's not there right now.
Okay.
And if it helps, if you want to send discovery subpoenas requesting the form, even though there's not a motion filed, I'm not going to object and throw a fit about it if that gets the forms faster.
All right.
I don't know why when she's in there, she just can't get a release form that she could then send to him through OFW. That's all.
And to the extent that can happen, that'd be great if it
Which
keeps
is what
everybody
did with
from
the
this.
therapist.
All right. And as far as the parenting time and the video, I mean, I get, especially my understanding is she's in the car right now, or he's in the car at camp and all of that. So there's some connection issues. But I do think, I don't like to do this, but I think given the allegations, I think they do need to be recorded.
Will our family wizard do that?
I think so.
Okay.
Yeah, I think so.
I like that just because it kind of takes both of them out of it.
Yeah. But again, it's not something that I want to continue forever and ever, because there really should be private conversations between dad and the child.
Yes. And so they have to have the max package, but she can record.
Okay. All right. Is there anything else?
Well, Your Honor, this is not part of the motion, but we had some parenting time scheduled for July that, due to a unavoidable work reassignment, my client is not able to make that trip. So I don't know, we're not asking for it, but we would like possibly a week and maybe the Christmas break for him to be able to see the child. I know that's not in the current parenting time order, but if the judge could give maybe some sense of its position on.
I think that would be appropriate.
Yeah, and talk to me. I don't know what she's got planned. So
we've got plenty of time at this point
Yeah.
for, I think, counsel to discuss it. But yeah, I'll just indicate that I think that would be a good idea.
Thank you.
Okay.
Okay, and so you're not awarding any cost at this point. Could that be reserved in the event that there's some issue that comes up in the future? Because quite frankly, I'm not hopeful, but I'm going to
I understand, but you know, the burden of proof for contempt is on the person bringing the motion, and I don't think it's met. I think there's too many factual questions here, as well as some ambiguity. I hope I've clarified that now, and it's clear. And so in the future, this court will definitely enforce it.
Thank you. I will prepare that order.
All right. Thank you.
Thank you.
Thank you, Your Honor.
DM. Both parties are present along with their respective attorneys. We are here on the defendant's motion, and on the defendant's motion in order to show cause against the plaintiff for contempt. Mr. Young.
Thank you, Your Honor. I'm not sure if you would like just a brief opening summation of what has brought us here this morning, but
it's your time. I mean, I've got the briefs, so
okay.
It's really up to you how you want to proceed.
Thank you. I would just indicate that I would rely upon the allegations set forth in the brief. The court is well familiar with these parties and this matter, and the parties, as you know, do not reside in the same country. The defendant father is in India, plaintiff mother is in Michigan, and so the contact he has had with his child has been through telephonic communications, and he has also visited on the summer for 1 month, and that is scheduled for this summer, hopefully, and it goes well. There has been a very clear direction given to the parties about cooperating with and setting up these calls that are really the sole source of contact between the minor child and the father. They are important, and my client has been very diligent in making sure he is available for those calls. And I think the proofs will show that in nearly all of these calls, there is no video. It is turned off immediately after the calls start. This has occurred while the mother is clearly present. And so our contention is that, pursuant to the February 28, 2025 order, that the calls were to be facilitated by the plaintiff is not being properly complied with. Additionally, it is our claim that the mother has been taking the child for evaluations, which, as the sole legal custodian, she is certainly entitled to do. But in those evaluations, there are statements and other facts that have been included, clearly indicating that the minor child has been put in a position where things have been communicated to him that result in him making false negative statements about his father. That clearly is in violation of the court order that would prevent plaintiff mother from saying anything to this child that is going to disparage the defendant father or put him in an unfavorable light. I think that if the court were to look at the history of this case, the mother has and continues to claim that the father is unsafe to be around the child. That has been related to numerous in pleadings before the court. I do believe that those are not based on any kind of factual basis. And so it makes the courts implementing a relationship or allowing a relationship to flourish between the son and the father next to impossible if there is this continued notion and narrative about the defendant being a danger to his son. So based on that, we are wanting to proceed with this contempt hearing and ask the court, after hearing the evidence and considering credibility of the parties, that it make a determination as to what sanction should be ruled against on the plaintiff's part. And included in that is, again, attorney fees for the defendant, who has, and I believe this is the fifth motion that we have dealt with. I believe the court has been very generous in giving mom the benefit of the doubt in prior actions. But I know that in Ingham County, there was clearly a determination that mom was not cooperating, and there was attorney fees imposed in that one instance several years ago. I don't have the exact date. So we are ready to proceed with the proofs from the defendant father on what has occurred concerning both the calls and the disparagement claim that he believes is contrary to the orders of this court.
Thank you. Ms. Neisler.
I think I'm going to emphasize that this is, I believe, actually the sixth time we have been here, and the last five, there's not been a finding of contempt, and we're looking at the same allegations. At the end of the day, what we're dealing with is a 6-year-old who's doing video calls, and I don't think there's anything deliberate, and I don't think he's going to be able to prove that mother is deliberately interfering with these calls. The parties have a tumultuous history, but I know since I've come on board, there has been what I would call meticulous compliance with the orders, and that I hope will continue. And I'm not seeing that a child turning off the video and then a half-hour phone call continuing to occur rises to the level of contempt, that we're dealing with a very young child in a very long-distance relationship. As far as the allegations about what mom is saying to the therapists and saying to the child, I think my first issue is that I don't see the therapist on the witness list. So we're going based off of hearsay contained within a report that's not admitted, and certainly I hope would not become part of the record even if we were to do. So if we do get to the point where the court is considering admitting that report, I'd ask that we do it under seal, just as sort of an aside so that the child's evaluation. But it's an evaluation that was deeply contemplated last time we were in court as far as selecting the provider, giving dad the opportunity to participate, ensuring it was someone who had the remote availability. So I will, based on how the testimony comes out about that, I will have more or less to add when I take my hour and a half that I hopefully don't need all of. But that should give the court a bit of an idea of where we're going in our theory of the case.
All right, thank you. Mr. Young.
I would like to call the defendant father, Ayud Kamath, if I could.
All right. Sir, would you unmute? Mr. Young.
Mr. Kamath, could you tell me what your relationship is or was to the plaintiff in this case?
We were married.
And you were divorced?
Yes.
And when you were married, were you residing in America?
Yes.
And did there come a time when you were no longer allowed to remain in the country?
Not really. I had to move back to India during my PhD for family reasons. My mother had been unwell, and I needed to move back to look after her, and she passed away shortly after that. And I needed to remain here to settle her estate and various other financial and professional obligations, and sort of carry all of them out. And after a certain point, yeah, so that's
Okay. And with regard to your desire to come back to the States and live in a closer proximity to your son, is that possible now?
I mean, given what we are seeing with the changes to H1B visa rules with ICE and other things, and the increasing sort of undermining of the law by the federal government, I would say increasingly no.
So what is
I
the
have,
pardon
I
me.
have in the past applied for jobs soon after my for a year or two after my PhD was completed. But yeah, at this point, I have not actively been looking. It's been 5 years. It's been 4 years,
So,
roughly 3.5, 4 years now.
so you are not in the foreseeable future going to be relocating to the States, living in the same community as your son. Is that correct?
I don't think I'm going to be able to. Yeah, even if I tried, I don't think I'd be able to. And so it would take a lot of time, effort, and money to do that, which, given the odds of success, don't really balance out
Okay. So
professionally. So yeah.
you, other than 1 month in the summer that you come to visit your son, what is the contact that you are able to have with him?
Other than the 1 month in person over the in July, it is the twice weekly calls on Friday and Saturday evenings Eastern time, which are the middle of the night, my time.
And how long has the court ordered or allowed you to have those calls with your son?
Since the divorce, but there was a period, I think in 2019, there was a period in 2020-ish when, for a while, when the calls were not happening, and I think that is when a contempt of court
I'm going to object to
was
testimony
found.
about anything that happened prior to the last time the contempt motion was denied, and ask the court if we can limit things to the dates in question, which started in October of 2025.
Mr. Young?
I will move on if the court please.
The court's aware of the history of the case.
Yes. So I'm wondering if, in your experience, since we were last in court over the telephone calls, I believe that was a year ago, maybe longer, have those calls gone smoothly?
Not really, no.
And could you describe for the court, if you could, and in particular, what you have attached to your motion as a summary of calls from October 3rd of 2025 through March 14 of 2026. Are you familiar with that summary of those calls?
I'm not familiar with the exact happenings on each call, but broadly speaking, I've tried to summarize whether the video was on or off at the start of the call, how the call was being set up, and whether, yeah, and basically I've focused on whether or not the calls have been set up, whether the camera was pointing at Matsya at the start of the call or not, whether the video was on at the start of the call or not, whether the audio was on at the start of the call or not, and if the video was switched off, under what circumstances they were switched off at the start, during the setup of the call.
Okay. Now, that is a summary that you prepared. Is that correct?
Yes.
And that was prepared contemporaneous to or simultaneous to the call concluding. Is that a fair statement?
I'm sorry, I don't quite understand the question. Sorry.
What I'm wanting to know is whether the summary that's attached to your motion is an accurate representation of what you just testified had occurred during each of those 43 calls.
To the best of my abilities, yes.
Yes. And if you could, can you tell the court if your ex-wife, the plaintiff in this case, was involved in the setting up of those calls?
In some calls, I could tell whether that she was, and in some, in some calls where the video was visible at the start, I could see her. Some calls, even when the video was not on, I could hear her. So, with some days the audio and video were both off at the start, so I didn't really know. So, but yeah, I don't know if does that answer your question?
Right. I'm just wanting the court to understand with these 43 calls, how many were problematic and how many were successful, correct?
I don't remember off the top of my head, but there are, like I said earlier, there are different parameters which I've tabulated, and different calls had different issues.
Now, you conduct these calls on Our Family Wizard platform, is that correct?
Yes, that I believe it was this court that directed us to switch from, I think it was Zoom earlier. Before that, it was Skype. So yeah, and right now we're on OFW. Yep.
So OFW retains a video of all of the calls that you've listed on your attached exhibit to your motion?
Yes. I think you need a specific kind of account that you have to pay extra for to access them, but yes.
And so you are prepared and are willing to present to the court the video from all of the calls you have attached, both 1 through 43. Is that a fair statement?
Sure, yeah. And as my lawyer, you also have access to my account. So I believe that the recordings in your possession were directly downloaded from the site without my intervention in any way.
Okay. So of the calls that you would like to have the court have its attention drawn to specifically, can you identify just some of the worst examples, I suppose, of the plaintiff's interference with these calls or inability to facilitate the calls?
Sure, if I could I don't remember the dates off the top of my head. I'm not very good with numbers, but if you allow me, yeah, so I mean, 27th February of this year is one of them. Then there's 13th of February, 28th November last year, 20th December last year, 31st October last year. These are just some of them which show different kinds of issues that have happened.
So in each of the calls you've just mentioned, do you see your son in the video call? Is his face there?
In a few of them, yes. Some no. It depends. So I have focused on the setting up of the call rather than what happens later on in the call in terms of my tabulations. In the setting up of the calls, in some instances, the video has been off at the start. In some, the video has been on, but it's not been pointing at Matsya. It's in one instance, it was pointing, I don't know, at some unidentifiable objects. In another, it was pointing at Ramya, and then it was turned off before I could see Matsya. So so there are different sort of issues in the different examples.
So with regard to the February 27 video. That is something that you believe demonstrates the problems generally that you've filed the motion about?
Sure, some of them, yes.
Your Honor, I would move to allow or move to have the court consider the proposed video of, I'll just select several, if the court please, and let the court see what has transpired if there's no objection.
You're muted.
Is there any objection? No, you're muted.
No objection.
All right. And we will stop
the virtual courtroom. We have
streaming
both parties
to
as well as their respective attorneys. We are here on the plaintiff's motion to modify parenting time. I have read both the motion and the response. Ms. Lynn.
Your Honor, I'll highlight just a few things in addition to the motion. First of all, I think Ms. Quakel conflated the timeline a little. After the previous order was entered in February of 2023, both parties have since married. And after entry of that order, Mr. Maljars and his wife have had 2 children. Owen is very bonded with his new siblings, and I'll note that Ms. Quakel is also expecting a child in the fall of this year. Second, when the last order was entered, Ms. Quakel lived with her parents, and they were heavily involved in Owen's day-to-day care. Now Ms. Quakel and her husband live in an apartment, and her parents are not as involved in Owen's care. Mr. Maljars has also since moved, and Owen has his own bedroom in the new home. Third, there are concerns about Owen not getting enough sleep while in Ms. Quakel's care. Owen's teacher has pointed out how tired Owen always looks, and Owen reports regularly staying out past his bedtime. Additionally, there are new concerns about Owen's diet while in Ms. Quakel's care. She packs Owen lunches with high sugar and processed foods, which is particularly concerning given Owen's severe dental issues. Lastly, I'll address an allegation that Ms. Quakel made about Owen waiting outside for parenting time exchanges and not wanting to spend time with his father. These allegations are totally baseless. On the occasion that she references, Owen went outside a few minutes before the exchange time because she had previously reprimanded him for being late for the exchanges, and now he just wanted to make sure that he was on time. Owen repeatedly expresses to Mr. Maljars how he wishes he could spend more time with him and his siblings. And as outlined in our motion, Mr. Maljars and the child have a very strong bond, and they do various activities together. Given these facts and those outlined in our motion, we believe that the threshold for proper cause or change of circumstances is met. And as such, we're requesting that parenting time be referred to friend of the court.
Thank you. Ms. Van Dyken.
Thank you, Your Honor. They have not met their threshold. What she just stated was everything that was in her motion. Quite frankly, a new child, a new marriage. When Ms. Maljars was living with her parents, that was a problem for Mr. Maljars. He thought they were doing all the parenting. So now she's remarried and living with her husband. That change is beneficial for Owen. Owen doesn't express wanting to spend more time with Mr. Maljars at all. In fact, he has some fear about the siblings and feeling like a third party because they have their own biological children. Your Honor, I don't think this meets the threshold. These are normal life changes. People get divorced, they get remarried, they have additional children. There's nothing in their motion that rises to the level of proper cause or change in circumstance. I know in their motion, though, they love to relitigate all of the past history. What we need to do is let this sit, let Owen get established in this parenting time schedule, which he is getting to. It's only been 2 short years. And to jump to ask for 50-50 when he has 6 overnights a month now to go to 15, sure, ask for the moon, but you'll land amongst the stars. No, that's not how this works. Quite frankly, Your Honor, the parenting time right now is what he is used to. It's routine, and he does well with this. We're asking the court to deny their motion at this time.
All right, thank you. As I earlier indicated, I did read the motion. I also read the response. I also reviewed the law in this situation. And I do not believe that these normal life changes rise to the level of proper cause or change in circumstance, particularly to change essentially what would be the custodial environment, I believe, to the parenting time that Mr. Maljars is requesting. So I will deny the motion at this time.
Thank you, Your Honor.
All right,
Here,
we're adjourned. Thank you.